Hello, I will be analyzing the 2025 Google AI Contractors layoff case. I will examine the situation through legal and regulatory lenses, looking at both Canadian and US frameworks. This case is particularly given the rapid expansion of AI development and the growing reliance on contractor workforces in the tech industry. The legal questions it raises have implications far beyond Google. I will be talking about what laws apply, whether they are adequate, and what alternatives exist for resolving such disputes. Let's start with the facts. In early 2025, over 2,030 third-party contractors working on Google's flagship AI products, including Gemini and AI overviews, were suddenly terminated. The workers tell one story: they had been raising concerns about pay and working conditions, and they believed the layoffs were retaliation for speaking up. This would potentially trigger several legal protections we will discuss. Google's position is different. They characterize this as routine business restructuring, nothing that third party vendor contracts are regularly reviewed. The key legal question is whether this was legitimate business restructuring or unlawful retaliation. The answer has major implications for how tech companies can treat their contractor workforce. The Canada Labour Code Section 240 provides a strong protection against unjust dismissal for federally regulated employees with at least 12 months of service. What makes this law particularly worker friendly is that dismissal must meet four criteria. It must be rational, proportional to any alleged misconduct, made in good faith, and procedurally fair. The remedies are comprehensive. Workers can receive full compensation for lost wages, reinstatement to their former position, and importantly, any other equitable remedy the educator deems fair. The giving adjudicators significantly flexibility. The challenge for the Google case is whether these contractors qualify as employees under the code. That is the threshold question. Section 246.1 is where Canadian law really shines for workers. It specifically prohibits reprisals against employees who file complaints, provide information about wages or conditions, or exercise their statutory rights. Here is the game changer. The burden of proof shifts to the employer. Once a worker establishes they engaged in protected activity and were subsequently disciplined, the employer must prove the action wasn't retaliatory. This is significantly departure from most legal frameworks where the person alleging wrongdoing bears the burden of proof. In practice, it means employers need to document legitimate, non-retaliatory reasons for any adverse action. For Google, this would mean they would need to prove the layoffs were genuinely about restructuring, not retaliation. A higher bar than simply denying the allegations. Moving to the US framework, the NLRA, National Labor Relations Act, is the foundational statute protecting workers' right to organize and engage in collective activity. Section 8A defines unfair labor practices. Section 8A1 prohibits interference with concerned activities. Importantly, this applies even to non-unionized workers who act together to improve conditions. Section 8A3 prohibits discrimination for union activities. Section 8A4 protects against retaliation for filing charges or testifying. The examples shown: threatening job loss, firing for organizations, disciplining for protected activities, are classic NLRA violations. Remedies include reinstatement, back pay, cease and desist orders, and posted notices admitting wrongdoing. However, there is no punitive damages, which some argue reduces the deterrent effect. The critical limitation: charges must be filed within 6 months. The statute of limitations is short, so workers need to act quickly. The Worker Adjustment and Retraining Notification Act addresses mass layoffs directly. It's about procedural requirements rather than justification. One applies to employers with 100 or more employees. It requires 60 days at advance written notice before either a mass layoff, like more than 500 workers, or 50 to 499 if that's at least 33% of the workforce, or a plant choosing affecting 50 plus workers at a single site. The penalties are meaningful: 60 days of back pay plus benefits for each affected worker, plus a civil penalty of a $500 per day to a local government. The question for Google is whether over 200 contractor terminations at a single vendor location triggers WARN. The numbers matter, and so does the question of who the actual employer is for WARN purposes. Let's compare these frameworks systematically. Unjust dismissal. Canada explicitly protects against unjust dismissal. The United States generally follows at-will employment, meaning employers can terminate for any reason that's not specifically prohibited. The burden of proof difference is dramatic. Canada puts the burden on employers for retaliation claims. In the US, workers bear the burden of proving discrimination or retaliation. Mass layoff notice requirements differ too. Canada requires 16 weeks notice for 50 plus federal employees, which varies by the province, while the US WARN requires 60 days for larger employers meeting specific thresholds. Both systems struggle with contractor status. Neither fully addresses the fissured workplace problem, where the workers are employed by vendors but controlled by the client companies. This is the core challenge in the Google's case. Now for the critical analysis. Are these laws adequate? The biggest gap is the contractor classification loophole. Third-party contractors often fall outside traditional employee protections. They are not employees of the company directing their work, so those protections don't apply. They are employed by vendors who may not have the resources or the inclination to fight back. Jurisdictional complexity compounds this. Multinational companies can structure operations to minimize legal exposure. Workers in one country may not be able to invoke protections from another. Enforcement delays are a practical problem in both systems. Canadian adjudication and US NLRB proceedings can take years. By then, the moment has passed, the workers have moved on, and the deterrent effect is diminished. On the positive side, Canada's burden shifting provision is powerful, and WARN Act penalties provide meaningful financial incentives for compliance. Here's the deeper question. Do these laws address the ethical dimensions of the workplace treatment, or are they primarily financial calculations? On the financial side, we see severance calculations, payback formulas, notice periods tied to tenure, and civil penalties calculated per day. These are important, but they are fundamentally about compensation. The ethical elements are there, but often secondary. Canada's just cause requirement recognizes worker dignity and beyond economic value. Protection of organizing rights acknowledges workers' humanity and agency. Anti-retaliation provisions protect workers' ability to speak up. Reinstatements as a remedy goes beyond money to restore the employment relationship. My assessment is that the Canada approach is more ethically grounded. The unjust dismissal standard asks whether the employer acted fairly, not just whether they paid enough. The United States approach is more transactional, treating workers largely as economic units whose losses can be monetized. The uncomfortable truth is that the both systems primarily compensate after harm occurs rather than preventing it. Neither adequate addresses the power imbalance in the contractor relationships or the ethical obligations of highly profitable companies to their workforce. Let's pivot on to non-legal alternatives, starting with alternative disputes resolution. ADR encompasses several methods. Mediation uses a neutral third party to facilitate agreement between parties. Arbitration involves a neutral making a binding decision. Facilitation provides structured support for dialogue. For this case, ADR offers several advantages. It is dramatically faster, weeks versus years for litigations. It is confidential, which matters for both workers' privacy and corporate reputation. It is less adversarial, which can preserve working relationships or at least make transitions smoother. And it can address underlying workplace issues that legal proceedings might not reach. Practically, workers and Google's vendor could engage in mediation to negotiate severance packages, address the pay concerns that sparked the conflict, and create transition support programs. Both FMCS in the United States, the labor program in Canada offers free mediation services for workplace disputes. These are underutilized resources. The limitation of ADR is that typically requires both parties to participate voluntarily. Companies with significantly power advantages may have less incentive to engage. The second alternative approach involves corporate social responsibility and multi-stakeholder initiatives, collaborative mechanism where companies, workers, NGOs, and sometimes governments create shared standards. The tech industry has several examples. The Responsible Business Alliance sets standards for electronic supply chain. The Fair Labor Association focuses on fair labor practices. The Ethical Trading Initiative promotes workers' rights in supply chains. These mechanisms have real strengths. They create industry-wide standards, include third-party auditing, and harness reputational pressure. When companies compete for talent and public trust, being seen as good employer matters. The limitations are also real. Participation is voluntary, enforcement is limited, and CSR can sometimes be performative, more about public relations than genuine change. For Google specifically, meaningful CSR could include extending their supplier code of conduct to cover contractor treatment, establishing worker grievance mechanism with independent oversight, and transparent reporting on how contractors are treated. Microsoft's supply chain of human rights statement is a model. It explicitly extends protection through the supply chain and includes the independent monitoring. If we wrap this up with four key elements, first, the protection gap is real. Both Canadian and US laws offer meaningful protections, but neither fully addresses the modern contractor arrangements. The fissured workplace creates accountability gaps that companies can exploit. Second, Canada leads on worker rights. The burden shifting provision in section 246.1 is particularly powerful. Workers facing retaliation have a much stronger position under Canadian law than the US law. Third, litigation isn't only path. ADR and CSR frameworks offer faster, less adversarial approaches that may achieve better outcomes for workers while allowing companies to address systematic issues. Fourth, ethics demand more than legal compliance. Google is enormously profitable. The question isn't just what they are legally required to do, but what they should do as a responsible corporate citizen employing tens of thousands of workers directly and indirectly. The Google case will likely be resolved through litigation, settlements, or simply time passing. But the underlying question about how tech companies treat their contractor workforce will only become more pressing as AI development accelerates and these arrangements proliferate. These are my references with all the applicable laws. For Canada, we have Section 240 covering unjust dismissal and Section 246.1 covering unfair retaliation, both in the Canada Labor Code. For the US, there is NLRA Section 8.A on unfair labor practices and the Warren Act on mass layoffs. The alternative approaches, the ADR and CSR MSIs round out all the links I will be providing. This is part 2 of my analysis of the Google's AI contractor layoff case. In part 1, I examined legal and regulatory frameworks. I'm going to step into different shoes or using different hats. I will take on 4 distinct roles: the affected workers, the corporation, society at large, and as a regulatory. For each, I will try to articulate not just what they think, but why they think it, what values, experiences, and concerns drive their perspective. This isn't about finding the right answer, it's about understanding that ethical disputes often involve genuinely conflicting values held by people acting in good faith. So before I dive in, let me explain why this approach is important. Every workplace dispute involves multiple stakeholders. The easy path is to pick a hero and a villain, like workers are good, corporations are bad, or vice versa. But reality is much more messier. Each party has legitimate concerns rooted in real values. Today I will explore 4 perspectives. First, the workers. Over 200 contractors who lost their jobs. Second, the corporation, Google and its vendor partner represented by management, legal and compliance teams. Third, society at large. You, me, citizens, users, other workers watching this. Fourth, regulatory. Specifically, I will speak as a Canada Industrial Relations Board. For each role, I will describe how they feel, what they believe is right and wrong, and most importantly, why they see it this way, what experiences and values shape their worldview. So let's get started. The worker. I'm now going to speak as one of the 200 plus contractors who were laid off. These are people who worked on Gemini on AI overviews, products that are central to Google's future. They showed up every day, contributed their skills, and believed that they were part of something important, and then suddenly they weren't. Let's try to capture how that feels. So, how do you feel? Honestly, betrayed. We weren't just doing a job, we believed in what we were building. We spent months training AI models, checking outputs, improving systems. Gemini exists in part because of our work. And Google is making billions from these products, but we are also afraid. When you lose your job, suddenly everything becomes uncertain. Mortgages, rent, healthcare, families. Some of us relocated to this position. We made life decisions based on this work, and now the ground has shifted beneath us. What feels wrong here? Look, we raised concern about pay and working conditions. That's supposed to be protected. You are supposed to be able to speak up without fear, and then suddenly we are terminated. Is that coincidence? Maybe, but it doesn't feel like coincidence. And here's what really burns. Google hides behind the vendor arrangement. When it's convenient, they direct every aspect of our work, what to do, how to do, when to do it. But when it is time to take responsibility, suddenly we are not their employees. We are the vendor problems. What we believe in is right. What workers should be able to speak up without fear. That companies benefiting from our labor owe us basic dignity, notice before termination, an explanation, fair treatment. We are not asking for lifetime job guarantees. We are asking to be treated like humans, not disposable inputs. Why do we see it this way? Because we have lived the power imbalance. Google has armies of lawyers and billions in resources. We have our skills and each other. When the powerful can silence the powerless for speaking up, that's not a free market, that is coercion. And we are not disposable. AI training requires human judgment, cultural understanding, nuance. We are not interchangeable cogs. Treating us like we are devaluates the very work that makes AI useful. The timing says everything. We complained, then we were fired. If it walks like retaliation and quakes like retaliation. Now let's change the hat and talk about as a corporation. So this will be harder because corporations don't always get sympathetic hearings. But if I'll be serious about understanding this situation, I'll try to engage with their perspective honestly. I'm now speaking as Google's management and the legal team, people responsible for running a company, satisfying shareholders, and yes, following the laws. Let me be direct about our position. This was a routine vendor contract restructuring. We regularly evaluate our partnership and workforce needs. That's not callous, it's how business operates. The timing with worker complaints was coincidental, not retaliatory. And I need to be clear on legal points that matters. These workers were employed by a third-party vendor, not Google. Their employment relationship and any disputes about it are between them and their actual employer. This is not technicality, that's structure both parties agreed to. What do we believe is right? Companies must be able to make workforce decisions to remain competitive and serve shareholders responsibly. That's not just our preference, it is a legal obligation. Efficient resource allocation creates the foundation for everything else. Jobs, innovations, the products millions of people use every day. We follow all the applicable laws. We have robust compliance programs. Legitimate restructuring isn't retaliation, and characterizing it that way undermines the distinction. What concerns us? If every business decision that happens near a complaint becomes potential retaliation, companies can't operate. You would create a system where filing grievance becomes a shield against any adverse action. No matter how justified, that's not fair either. Why do we see it this way? Start with fiduciary duty. We have legal obligations to shareholders. Efficient resource allocation isn't called. It's what we stay viable, continue creating jobs, and keep innovating. A company that can't make hard decisions doesn't survive. The vendor arrangement isn't a trick. It's a legitimate business model used across industries. It provides flexibility for both companies and workers. Many people prefer contracts work for the variety and freedom it offers. And on the timing, restructuring is decision involve months of planning, analysis, and approvals. Business doesn't stop because someone filed grievance. The timing may be unfortunate, but the correlation isn't causation. We are not villains here. We are trying to run a company responsible in a competitive environment. Now let's zoom out and beyond the workers and the corporation, there is a broader public watching this unfold. Citizens, users, other workers wondering if this could happen to them. I will now try to speak as a society at large, as someone who uses Google products, works in the modern economy, and cares about how we organize work in the age of AI. How do you feel about this? Uneasy, honestly. If Google can do this to contractors building their flagship AI products, what does it mean for the rest of us? AI is transforming every industry. Are we all going to contractors with no protections? But we are also conflicted. We want innovations, we want affordable, useful services. We benefit from what these companies create. The question is, at what cost to workers? And is that a cost we are comfortable with? What concerns us, the president mainly, if workers who train AI can be silenced for raising concerns, who will speak up when AI systems have problems? These aren't abstract products. Gemini and AI overview shape what billions of people see, learn, and believe. We need the people building these systems to be able to flag issues. There is also the trust erosion. Tech companies tell us AI is safe, beneficial, aligned with human values. But if they treat their own workers this way, the humans training and checking AI outputs, how much should we trust their assurance about the technology itself? And here is a bigger picture. The gig economy is becoming the whole economy. If contractor arrangements mean no worker protections, we are building a future where most of us are vulnerable. Today it's Google's AI contractors. Tomorrow it could be any of us. Why do we see it this way? Because AI affects everyone. What happens if Google sets expectations for the whole industry? Today's exceptions becomes tomorrow's norm. And there's something that feels broken about a social contract where companies can profit enormously while treating workers as disposable units. Companies exist within the society, not above it. When the relationship gets too one-sided, something needs to change. Finally, let's consider the perspective of those tasked with actually resolving the disputes like this. I will now try to speak as a Canadian Industrial Relations Board adjudicator who must apply the law fairly while recognizing its limitations. This is perhaps the most constrained role. We don't make the rules, Parliament does, but we have to apply those rules to situations the drafters never imagined. Our mandate is clear. We enforce the Canadian Labour Code impartially. Our job isn't favor workers or employers. It's to apply the law as written and ensure fair process for all parties. That sounds simple, but that is not. Every decision we make sets precedent. We must think beyond the specific case to how our ruling will affect future disputes, future workers, future companies. The questions we must answer are concrete. First, are these workers, employees under the code, or does the vendor arrangement place them outside its protections? This is a threshold question that determines everything else. If they are covered, did they engage in protected activity? Filing complaints about conditions generally qualifies, but we need to establish the facts. And then the burden shifts. Can the employer prove their termination weren't retaliatory? Under Section 246.1, the burden falls on them, but they get a fair opportunity to meet it. What concerns us, honestly, that the law wasn't written for this situation. The Canada Labour Code assumes traditional employment relationships, the fissured workplace, where one company directs work while another technically employs the workers. This didn't exist when these statutes were drafted. We have to apply rules from different era to workplaces that look nothing like what Parliament imagined. That's uncomfortable. We are not supposed to be making policy. That's the legislature's job. But refusing to decide doesn't help anyone either. Why do we see it this way? Rule of law matters. We don't make the rules, Parliament does. Our role, interpretation and application, not activism. Activism. If we overreach, we undermine the democratic process and our own legitimacy. But procedural fairness also matters. Both sides deserve to be heard, to present evidence, and to receive reasoned decision. Justice requires process, not just outcomes we think are right. And precedent matters. Our decisions guide future cases. A ruling that seems right for these particular workers but creates unworkable rules for other fails everyone. We have to think systematically. So there we have four perspectives, each with internal logic, each grounded in real values and legitimate concerns. But of course, they can't be all right simultaneously. So let's look at where these positions fundamentally clash with each other. The first clash is definitional. What count as employment? Worker says Google directs our work in every meaningful way. We are employees in everything but name. the contractor label is the contractor label is technically designed to deny us rights. The corporation responds, legal structures exist for good reasons. You choose to work for the vendor with different benefits and trade-offs that direct employment. That was a choice. This isn't just factual dispute. It's about what should determine worker protections, control of work, or the formal employment relationship. Both views have merit. The second clash is about causation, retaliation, or coincidence. Workers say we accompanied when then we were fired. The timing is everything. They wanted to silence us. The corporation says restructuring takes months to plan. Business decisions don't stop because of complaint. Correlation isn't causation. Again, both perspectives are defensible. We often can't know true motivations. That's why the burden of proof question matters so much. The third clash is about values, individual rights versus business efficiency. Society says worker protections exist for a reason. Efficiency shouldn't mean people can be discarded without consequence. The corporation's response, over-regulation makes companies uncompetitive. The cost, job, and innovation in the long run, hurting everyone. So this is a genuine value trade-off. More protection for current workers might mean fewer jobs overall. Less protection might mean more precarity for everyone. Neither outcome is obviously right. The fourth clash is perhaps deepest, law versus justice. Workers and society says if the law doesn't protect workers in modern arrangements, the law is failing its purpose. It needs to evolve. And regulatory response, we apply the law as written. Changing it is the parliament's job, not ours. Judicial activism undermines democracy. So this tension between what the law is and what it should be runs through our entire legal system. It has no easy resolution and it applies to all of the world. So how might these clashes be resolved? Let me outline four possible paths. First, negotiation settlement. Workers and companies negotiate directly, perhaps through mediation. Workers get compensation and acknowledgement. The company avoids prolonged litigation and reputational damages. Both sides give something. No legal precedent is set, which might be a feature or a bug depending on your perspective. Second, legislative reform. Parliament updates the Canadian Labour Code to address modern contractor arrangements. This could include clearer rules for joint employment when the client companies control contractor work, or specific protections for platform and gig workers. Companies face new obligations, workers get clarity. This is probably the cleanest solution, but the legislation is so slow and politically difficult. Third, judicial interpretation. Courts or tribunals interpret existing law expensively, finding that Google's level of control over contractors make them de facto employees regardless of the formal arrangement. This would set powerful precedent, but it might also trigger corporate restructuring to avoid the ruling or political backlash against perceived judicial overreach. The fourth, industry self-regulation. Tech companies voluntarily adopt stronger contractor protections, codes of conduct, transition support, grievance mechanism with independence oversight to get ahead of the regulation and maintain public trust. This is faster than legislation, obviously, and more flexible, but enforcement is uncertain. And critics argue corporate self regulation is often more about public relations than the genuine change. Here's an uncomfortable truth: these conflicts might not be fully resolvable. Different stakeholders have genuinely different values and interests. The best we can do is create processes that are fair, transparent, and responsive to changing conditions while acknowledging that someone will always feel the outcome is unjust. That's not a just satisfying answer, but it is an honest one. So let me close with four key takeaways from this exercise. First, perspective matters. Each stakeholder we examined has legitimate concerns rooted in real values. Dismissing any perspective as simply wrong or bad faith misses the complexity of workplace ethics. Understanding doesn't mean agreeing, but it is the starting point for productive dialogue. Second, structures shape power. Legal arrangements like contractor status aren't neutral technical choices. They distribute power and determine who has voice. When we choose a structure, we are making an ethical choice, not just a business one. Pretending otherwise is a form of moral evasion. Third, law lacks reality. Our legal frameworks were built for a world of stable bilateral employment relationships. Technology creates new arrangements faster than law can adapt. When that happens, ethical leadership must fill the gap. Companies can't hide behind "we followed the law" when the law hasn't caught up their practices. Fourth, resolution requires process. When the value genuinely conflict, fair process matter more than determining outcomes. Dialogue, transparency, and accountability can't eliminate conflict, but they can make it constructive rather than destructive. The Google contractors case will be resolved somehow through litigation settlements or simply the passage of time, but the underlying question about how we treat workers in the AI age will only become more pressing. This case is a preview of debates we will be having for decades. Who counts as our workers? What do profitable companies owe to those who create their value? And how do we build an economy that works for everyone, not just those on top? I think those are the questions worth sitting with. Thank you. Welcome to part 3 of this analysis, the techno-social impact. I have covered legal frameworks and explored different stakeholder perspectives. Now let me examine how the underlying technology itself implies and complicates these issues. This isn't just about one layoff at one company, it's about understanding how AI technology creates new forms of work and new forms of harm that existing systems aren't equipped to handle. So let me start with these workers were actually doing. The Google contractors weren't doing data entry or customer service. They were training large language models like Gemini and AI overviews, systems that shape what billions of people see, learn, and decide every day. This work involves three main activities. First, AI content moderation. reviewing and labeling content to teach AI what's harmful, inappropriate, or misleading. These decisions directly affect what billions of users experience. Second, data labeling, transforming raw data into training material. Every label shapes how AI thinks, making these workers architects of machine intelligence. Third, AI third, they are subject to algorithmic control. Their own productivity is monitored by algorithms, with quotas and rating determining their employment. So here is the paradox. These workers are essential to AI development. They are the human in the loop that makes AI safe and useful. Yet the same technology they train is used to monitor, evaluate, and ultimately control them. They are building the system that manage their own working condition. Now let's look at how technology specifically amplifies legal challenges in cases like this. First, the scale. AI companies need thousands of workers globally to train models. When problems occur, they affect workers across multiple countries simultaneously, making coordinated legal actions nearly impossible. How do you organize workers spread across Kenya, Philippines, Colombia, and India? Second, layered outsourcing. Tech giants contract with vendors who subtract further. This creates legal distance. Google can claim it's not the employer even while directing every aspect of the work. The more layers, the harder they assign responsibility. Third, NDAs and silencing. Workers sign strict non disclosure agreements. Many can't even discuss their trauma in therapy without fearing legal consequences. This isolates them from support system precisely when they need the most. Fourth, jurisdiction shopping. AI work can be done anywhere with internet. Companies locate operations in countries with weaker labor protections, creating a race to the bottom for the worker rights. The enforcement gap is real. Labor laws were designed for factories where you could see employer and count the employees. Digital work happens in the cloud, across borders, through layers of contracts. By the time regulators catch up, the work has moved somewhere else. Now let's talk about what I think is the most disturbing aspect of this case: the psychological trauma inflicted on content moderators. To make AI safe, workers must review humanity's worst: child abuse imagery, extreme violence, torture, self-harm, hate speech. They do this for 8 or more hours daily, often under strict productivity quotas. Imagine spending your workday watching videos of murder, sexual assault, and child exploitations, then being told you need to work faster. The documented health impacts are severe. PTSD symptoms including flashbacks, nightmares, and hypervigilance. Depression and anxiety disorders, panic attacks and insomnia, relationship breakdowns and social withdrawals. Research shows a direct dose response relationship. More frequent exposure leads to higher psychological distress. Daily exposure causes significantly greater harm than less frequent exposure. The numbers are striking. Studies find 25 to 33% of content moderators show moderate to severe psychological distress. 33 to 50% score at level associated with clinical depression. Over 140 Facebook moderators in Kenya alone have been diagnosed with severe PSTD. This isn't an unfortunate side effect, it's a predictable outcome of how industry is structured. The consequences ripple outward from individual workers to organizations and society. For organizations, high turnover means traumatized workers leave, taking institutional knowledge with them. Quality degradation occurs as burned out moderators make worse decisions, affecting AI training. And legal liability is mounting globally as harms becomes documented in lawsuits. For workers, beyond the psychological trauma, they face constant job insecurity from gig arrangements. NDAs prevent speaking about trauma even in therapy, and their skills don't transfer. They can't even discuss what they did on a resume. For society, trust in AI erodes when people learn how it's made. A chilling effect emerges when workers are afraid to report AI problems, and there is troubling patterns of wealthy countries exporting psychological harm to poorer ones. For AI itself, exhausted, traumatized workers make inconsistent labeling decisions, introducing bias. Work concentrated in specific regions creates geographical and cultural blind spots. Rushed moderations means harmful content slips through. Here is a vicious cycle. Mistreating workers degrades the AI they train, which creates more problems, which requires more moderation, which burns out more workers. The human cost becomes an AI quality problem. The Google's contractors weren't just affected by AI, they were caught up in the intersection of AI and the gig economy. This combination creates a uniquely precarious situation. Consider how stressors compound. Job insecurities plus trauma means you can't process what you have seen when you are constantly worried about your next paycheck. Algorithmic controls plus quotas means you can't take mental health breaks when algorithms track your productivity in real life. Income volatility plus healthcare needs means you can't afford therapy when your income is unpredictable. Research from Rice University describes what they call the feedback trap. Workers receive negative ratings or misquotas due to trauma related performance issues. This negative feedback increases job insecurities and stress. Increased stress impairs the next day's performance. The cycle repeats until the worker burns out or terminated. Unlike traditional employees, gig workers have no managers to advocate for them. Their livelihood depends entirely on maintaining high ratings from automated systems. Systems that don't account for the psychological toll of the work. The Google contractors who raised concerns about pay and conditions were exercising a fundamental right, the ability to speak up about workplace problems. But the technology creates both new mechanisms and new barriers for worker voice. The silencing mechanisms are powerful. Broad NDAs means workers can't discuss what they have seen or experienced, even with therapists. Fear of retaliation is real. Speaking up leads to termination, as alleged in the Google's case. And contractor status means fewer legal protections for whistleblowing than employees have. But workers' voice matters enormously. For AI safety, workers see problems with AI systems before they reach users. For working conditions, only workers know what's sustainable versus burnout inducing. For public interest, society needs to know how AI is being built and at what cost. Here is the irony. These workers are teaching AI to moderate speech, to identify what's harmful, misleading, or inappropriate. Yet their own speech about working conditions is suppressed. The people making AI safe for disclosure are denied safe disclosure about their own work. One worker told researchers, I signed the NDA like everyone else, didn't think twice at that time, but now it feels like a trap. I'm living with nightmares from the content I saw, but I can't even talk about it in the therapy without feeling I'm violating the NDA. So let me conclude with four key takeaways. First, technology amplifies harm. AI doesn't just create new jobs, it creates new ways to harm workers. Scale outsourcing, algorithmic control, and content exposure combine to produce psychological damage at industrial scale. Second, the human cost is real. PSTD, depression, anxiety, relationship breakdown. These aren't abstractions, they are documented outcomes affecting thousands of workers who make AI safe for the rest of us. Third, legal gaps persist. Laws designed for physical workplaces struggle with digital labor. Outsourcing chains, global distribution, and contractor classifications create accountability voids that companies exploit. Fourth, voice is essential. Silencing workers through NDAs and retaliation doesn't just harm them, it prevents early warning about AI problems and perpetuates cycles of abuse. As one report put it, the AI industry has created a new factory floor of exploitation, and labor protections must catch up. The Google Contractors case isn't an isolated incident, it is a window into how AI is being built and what it costs the human behind the machines. And these are my references. Uh, this will be the part 4, the self-reflection portion of this analysis. I've covered the legal frameworks, explored multiple stakeholder perspectives, and examined the techno-social impact. Now it's time to turn inward. This section is personal. I'm going to discuss how my own values shape my judgment of this case, how I would approach if I were in the regulatory seat, and what this case suggests about my future role in AI-driven society. This isn't about finding the right answer, it's about being honest and about who I am and what brings to these questions. So before analyzing any case, I need to acknowledge that I bring my own values. So these values are inevitably shape how I interpret with facts, weigh competing interests, and reach conclusions. Uh, so my educational background in the technology and data analytics give me appreciation for both innovation benefits and its potential for harm. I understand how systems scale in computer engineering from the ground up and how that scale can amplify the problems. My professional experience in technology leadership means I have seen how business decisions affects real people. I've seen legitimate reasons why companies structure work as they do. This gives me the perspective on both sides. At my core, I believe that people deserve to be treated with dignity regardless of their employment classification. A contractor label shouldn't mean a person can be discarded without consideration for their well being. I also need to acknowledge my bias here. I have a tendency to sympathize with the workers in power imbalances for obvious reasons. I tried to counterbalance this by genuinely engaging with the corporation's perspective through this analysis. But my starting point matters. Acknowledging my value is it's intellectual honesty. Every analyst, regulatory, or the judge brings values to their work. The question is whether they are aware of them or not. So, would I resolve this differently than the Canada Industrial Relations Board might? Honestly, I'm not sure I would or I should, but let me walk through how I would approach the decision. There are things I would examine closely. First, the control test. Did Google direct the work in the ways that make contractor a legal fiction? Second, the timeline. When exactly was the restructuring decision made versus when companies were filed? Third, the pattern. Were other non-complaining contractors also terminated, or only those who spoke up? Here's my likely approach. On employment status, I would lean towards finding these workers are covered by the Canada Labour Code based on Google's actual control over their work. On retaliation, I would require Google to prove non-retaliatory motive. The timing creates reasonable suspicion that shifts the burden to them. On remedy, even if the terminations weren't technically retaliation, I would consider whether proper procedures were followed. Where would I struggle? The hardest part would be staying within my role as a regulator. I apply the law, I don't make it. Even if I think the law inadequate for modern work arrangements, my job interpretation, not activism. That tension would weigh on me. Bottom line, I would probably reach a similar outcome to what the board might reach, but I would write decision that clearly signals to Parliament that the law needs updating for the AI age. So let's discuss the principles that weighed more heavily in my analysis. Like number one will be the human dignity. Every person deserves to be treated as an end in themselves, not merely as means to corporate profit. Workers who build AI systems that generate billions in value deserve basic respect, notice, explanation, fair treatment, regardless of their contract status. Number two would be fairness. Power imbalances don't justify exploitation. When a $1 trillion company structures arrangements to avoid responsibility for workers who create its value, something is fundamentally unfair, even if it's technically legal. The number three is the voice. Workers must be able to raise concerns without fear. This isn't just about individual rights, it's about systems health. AI systems need human feedback to work properly, and probably it will be so in the following years as well. Silencing that feedback harms everyone. Number four, the rule of law. Legal structures matter. Companies can't be allowed to use technicalities to evade the spirit of the worker protection laws. When the substance and form diverge too far, the law loses legitimacy. What weighted less heavily for me? Efficiency argument carry less weights when the inefficiency is treating humans humanely. Shareholders' values doesn't override basic ethical obligations. And legal formalism. We follow the letter of the law isn't satisfying when law clearly hasn't caught up to reality, obviously. I don't want to pretend this case is simple. Even with my values clearly stated, I feel genuine tension between competing goods. Let me be honest about where I struggle. First, innovation versus protection. I benefit from AI. I use these tools, maybe not daily, but the contractors' work made that possible, obviously. But if we overregulate, do we slow innovation that ultimately helps everyone? I don't think worker protection and innovations are truly opposed, but I acknowledge the argument. Second, global versus local. Stronger Canadian protections might just push work to countries with fewer protections. Have I actually helped workers or just moved the problem to somewhere else? I think this is a real concern and I don't have a complete answer here. Third, certainty versus flexibility. Some workers genuinely prefer contract arrangements for the flexibility they offer. Treating all contractors as employees might harm those who choose this path voluntarily. One size fits all solution rarely fits all. The fourth, present versus future. Helping these specific workers matters, but so does setting precedent that work for the long term. Sometimes the right decision for today creates problems tomorrow. Balancing these time scales is genuinely hard. So these tensions don't paralyze me. I still have a view, but acknowledging the complexity is a part of taking this case seriously. Anyone who finds this case simple probably isn't thinking hard enough. This case has made me think seriously about what role I want to play as AI transforms work, law, and society, whether as a policymaker, investigator, technology leader, or educator. Here is what I learned about what's needed. First, technical literacy. Future regulatory policymakers must understand the technology they are regulating. They can't make good AI policy if they don't understand how AI systems are built, trained, and deployed. I'm grateful my background gives me some of this foundation. Second, bridge building. Someone needs to translate between technologists, workers, regulators, and the public. Each group speaks a different language. I would want to be someone who can facilitate understanding across these groups. Third, ethical courage. It's easy to go along with the status quo. Harder to say this isn't right when powerful interests benefit from the current arrangements. I want to develop the courage to speak up like the contractors did, even knowing the risk. Fourth, systems thinking. AI problems aren't isolated, they connect to labor law, mental health, global inequalities, and democratic governance. I need to see the whole system, not just individual pieces. So, my commitment, I want to be part of building an AI driven economy that works for everyone, not just shareholders and consumers, but the workers who made it possible. That's the future I want to help create. So, what this case taught me, lesson one, the invisible becomes visible in crisis. The Google contractors were invisible until they spoke up. Most AI workers remain invisible. So, part of my role, whatever form it takes, is to make the invisible visible, to show the human cost behind the technology we all use. Lesson two, law follows technology, not the other way around. Legal frameworks always lack innovation. The gap is where harm happens. Ethical leadership means acting before the law catches up, not hiding behind the outdated rules. Lesson 3, multiple perspectives are essential. I learned more from genuinely engaging with the corporation's view than from dismissing it. Understanding doesn't mean agreeing, but it does mean taking opposing views seriously enough to articulate them fairly. The lesson 4, personal values matter professionally. I used to think objectively meant having no values. Now I understand it means being transparent about values while remaining open to evidence and argument. As I see it, the question is not whether we have the values, but whether we have the courage to act on them. This case challenged me to articulate what I believe and to consider what I'm willing to do about it. In the end, this case isn't just about Google or 200 contractors, it's about what kind of AI driven society we are building and what role each of us will play in shaping it. I've shared my values, my judgment, and my aspirations throughout this presentation, and I've tried to be honest about my biases and genuine in engaging with perspectives I don't share, and thoughtful about the complexity involved. Uh, Thank you, and this will be the end.